everyone. Welcome to this very special edition on Njenge Media TV titled Nnamdi Kanu's Sentence for Life, the Consequences, and What Next. Today, we gather in a moment of profound significance as a Nigerian court has just handed moments ago, about 2 hours ago, a life sentence to Mazen Nnamdi Kanu, the leader of indigenous people of Biafra, IPOB, marking a historic turning point in a saga that has captured the attention of Nigeria and the world. This verdict today comes after a turbulent trial. Kanu was convicted on seven terror-related charges, including incitement, issuing stay-at-home orders, and broadcasting messages that the court deemed preparatory to violent acts. The federal government had pushed for the death penalty, but Judge James Omotosho opted instead for a life sentence, citing not only the severity of the offenses, but also global opposition to capital punishment. In delivering this judgment, the judge did not mince words. He described Kanu's action as terrorist in nature, emphasized his role in ordering sit-at-home campaigns, and criticized his inflammatory broadcast. Yet, he also invoked a measure of mercy, highlighting both international norm and moral reflection. At some point, many of us were referred to Matthew 23. He ordered that Kanu be kept in protective custody, barred from access to digital service to digital device, and that his broadcasting equipment be forfeited to the federal government. The implications of this ruling are enormous. On one hand, this sentencing could seen as a strong affirmation of the Nigerian state resolve against what is deemed as violent separatism. On the other hand, many will wonder, what does this mean for political dissent, for the future of Biafran movement, and for the rights of those who feel marginalized? How will IPOB and its international supporters react? What are the legal avenue left for Kanu? And what does this verdict signal about Nigerians' approach to terrorism and self-determination? To help us unpack all this, the legal ramifications, the political fallout, and road ahead, I have here joining me from the United States of America, Barrister Emeka Ugonye, a distinguished lawyer and expert in constitutional and human right law. Barrister, thank you very much for agreeing. I know you're so busy, but you agreed to join me this evening. I appreciate that. Thank you once more for joining me.
You're welcome.
Now, let me quickly fire the first salvo. On legal basis and charges here, could you walk us through the 7 counts on which Nnamdi Kanu was convicted? And what is the legal basis for each in Nigerian law? I mean, when the judge talked about issue of terrorism, he relied on count 1, 2, 4, and 6, and those, in according to the prosecutor, carried death sentence, but which the judge refused to go along that argument. So, could you walk us through the 7-count charge, please?
Yes, the Nigerian government built its case based largely upon the statements made by Nnamdi Kanu over the years, from 2014 until the moment he was captured in Kenya and brought into Nigeria. As we know, and as I have said earlier, for the entire period of 4 years, Nnamdi Kanu was free to speak as he liked, and he said a lot of things. And, Nigerian government would have been able to fashion up to 50 count charges, because each statement, each could be an independent incitement charge, and even independent treasonable felony charge. But the government, after a series of back and forth blunders, they managed to fashion out 7 counts. And those counts were based on him. One, the treasonable felony count was based on him calling for secession and doing it in a manner that constitutes intimidation. Because the way that law is defined, if you engage in an act to overwhelm, intimidate government agencies, that is treasonable felony. Right. So his threats about secession, asking people to sit at home, all these things were sufficient pressure to justify that charge. And that charge has been there all along. So the charge was there when he was charged in 2015. What had happened over time was that he built up additional facts to strengthen that charge. Perhaps if the charge was tried based on the facts that existed in 2015, it wouldn't have been strong enough to convict him. However, subsequent activities after the initial arrest strengthened that charge. There were new facts put in place. So I am not surprised that they convicted him on that. There were other things like his threats and defamation of the president, which is actually count two. I was hoping that that count would be rejected because the president was dead and all that sort of thing. But apparently, none of those 7 counts were eliminated. Then you go into the terrorism charges. From count 4 to 7 were terrorism charges. They were based upon him inciting people to do things that could constitute terrorism if done and they were done. For instance, you tell people if you don't sit at home, you'll be killed. And as a result of this fear, they sat at home. Those who did not sit at home were killed, just as you threatened. That was sufficient. Really. So all the counts were well founded. One confusion people had was the idea that it was repealed law. That was so ridiculous. What matters is what was the law in force when you committed a crime? What was the law that was in force that time? The law in force was 2013 amendment, Terrorism Prevention Amendment Act 2013. That act was subsequently repealed in 2022 when the new Terrorism Act emerged. So when they say they repealed the law, it only means that if you commit the offense now, you will be charged under that old law because it has been repealed. Okay? But so people don't understand. The fact that a law was repealed doesn't mean that crime committed under that law cannot be tried. But in any event, the new act specifically saved in section 98 of the new Terrorism Act, 2022 Terrorism Act, it specifically said that anything done in the past under the old law could still be prosecuted. So the emphasis on repealed law is something very bizarre. And the emphasis on written law, saying that the law was unwritten, was even more bizarre. What Nnamdi did was he read section 36 of the Constitution, and that section says that a person cannot be tried except under a written law. That's what it says. That is the premise. So Nnamdi then concluded that that requirement of the Constitution was never met. And this was fed to his followers. And his followers began to say, what written law? And I was surprised to see him in court repeating the same very banal argument. What written law? The written law was the Terrorism Prevention Amendment Act. That is the written law. That law was a written law at the time he committed the offense. And by the way, the reason the Constitution provides that a law should be a written law before you try a person is because, you see, we don't want a situation where you are trying people of crimes they did not know existed. If you are allowed to try people just by creating the offense, what the Constitution wanted to avoid was a situation where the government could just pick you up and charge you with a law that never existed. They just made it up. They don't want them to be making up laws and charging people under such laws. So they wanted to make sure that the law under which a person is charged was known, was something the person could have known. That is the requirement of it. So in this trial, it was so obvious that the Terrorism Act is a written law. It's a writing. There's a booklet. You can see it. It was passed by the legislature. The bill was passed by our legislature, assented to by the president, and now being enforced by the court. So it is the most bizarre thing. When I listened to him or watched the display in court today, I was so shocked. It was so strange, really, because he was saying these things, and they didn't make sense at all.
Okay.
They didn't make sense.
Now, let me play this video. This was in court today.
Yes.
Because at some point, many of us who are not legal experts, personally, I got confused, because this is about the final submission, right? The final written submission. And he made this point here, and therein I will build my next question. Please, can you explain this to many of us who are watching but who did not understand what transpired here?
Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my lord, must be granted. I have not waived it, my lord, and I insist that I address this court on all these issues. My lord, do not forget.
Okay, so here, did the judge prevent him from reading his final written address? What was actually the issue?
He was talking nonsense. Absolute nonsense. Okay. You see, let me explain.
Why is it nonsense? He's telling the, he referenced Emeka Itiaba SAN, saying that Emeka Itiaba also agreed in the last court sitting that there would be a final written address. Is it that he did not write one, or what is it? I mean,
no. Let me explain what is the final written address. After arguments have closed on both sides, the prosecution made his case, the defense made his case. The judge will ask them to prepare final written address. That is to summarize
all the presentations,
the arguments, and all these things. It's to make it easy for the court. And then they will make what we call closing argument. In Nigeria, it's called adoption of the final written address. In the United States, it's a closing argument. So it is a summary of the cases presented. You are helping the judge. It is not a time to produce new evidence. It is not a time to produce new facts. It is actually not relevant for the trial. It is the judges do that routinely, but it could be dispensed with without affecting the trial at all. This is a case that has lasted 10 years. And the judge needs to get this case over. And if you look at the issue of final written address, it was dispensed with after Nnamdi fired his lawyers. I am sure that if his lawyers were there, the court would probably allow them to do that. But it is not a requirement. It is not specified in the Constitution, in the Section 36. The Section 36 basically says that a person should be given reasonable, adequate opportunity to defend himself. But written address is not a time when you defend yourself, more or less, because you defend yourself when, one, you produce your own evidence to advance your theory, or to contradict or to controvert the prosecution's case. It is done during your trial. Nothing new can come in. Your final written address is an analysis of what happened. This is what it is, what it is. But it doesn't really affect the substance of trial. No new evidence can come in. Nothing new can come in, really.
Okay.
So by the way, Itiaba when he was there, if he said those things, must have been saying, well, in the final written address, you can do this, because he thought it could happen. Maybe he thought there will be one. Because maybe they thought, Achebe did not know that Nnamdi would fail to put up a defense. When you did not put up a defense, what is going to be in your final written address? What are you going to do in your final written address? Are you going to be analyzing the evidence of the prosecution? The prosecution, it's prosecution to do that. So a person who did not present a defense, what is he going to summarize? Really? So apparently, Nnamdi was enjoying his advocacy. It's obvious, even if you listen to his tone, his listening, he was calling the judge, my lord, honorable court, my honorable lord, all those things. But then he flipped a few minutes later and began to insult the judge. So Nnamdi was in a theater. He wanted, in my opinion, he really wanted to show his followers that he could do better than lawyers, that he could speak better than lawyers. So if you see the vibe with which he was making his submission, but it was pointless. A lot of the things he was saying were absolute nonsense. There is so much bizarre thing that happened in this case. For instance, I was watching and I saw a lawyer, my friend, standing there dressed in traditional attire. I wondered, you know what?
But he's a consultant. He's no longer his legal representative.
You know what? He could still have addressed like counsel.
No, but he doesn't want to hold any. He doesn't want to hold any responsibility anyway.
Thank you very much. That is it. The only news that
Nnamdi was. He said so because even when the judge called him to give in what's it called allocutor.
Yes,
allocutors, and he said no, that he's not representing him, and he moved that to the House of Rep member who came in there, right?
Yes.
So
it was a clever move, but you know the funniest thing, the mistake here was that if Nnamdi I knew wanted to talk, a person facing politically related charges would like to talk because it is a way to send a message to his followers. I understood it. But his lawyers could have focused on their locutus moment. They will say, hey, don't worry. At the end of it, after conviction before sentence, the judge is going to give you the opportunity to address the court. That was going to be the Mandela moment. That would have been his Mandela moment.
But what could he have said? Because recall that he doesn't want to show any form of weakness.
No,
and but the judge also said he could have been more humane in his response. So
let me tell you something.
Okay.
Let me tell you something. What you could have said. Listen. That's why I call it Mandela moment. If you remember, Mandela did not apologize or show remorse, but he explained his position, justified his position, and created history. Since he will be convicted anyway, since he's already been convicted, all he needed to do was to now advance the argument for Biafra. He would have spoken about the persecution of the Igbos in Nigeria. He would have spoken about his wish for a happy country where he would belong, everybody would be happy. He would have talked about his dream of a great Nigeria where all people would be equal, where all people would be respected. But sadly, he found a Nigeria where the government stood by and watched that his people were being killed, where the government failed to do something about the Fulani men attacks, where the government left people poor, where he could have, oh my goodness, he could have said something today that would have shaken every Igbo person. He could have talked about prosperity, our chances for greatness, how we became poor, how the ports and the infrastructure of the Southeast were devastated, how we were promised that there was no victor, no vanquish at the end of the Civil War, and yet there was a vanquished people. You could have talked about poverty, talked about a whole lot of things, talked about what drove him. He could have said, my Lord, I would have wanted a peaceful life. I would have wanted to just be happy. drink palm wine with my people. But I came home and this is what I'm faced. And I chose this because I knew the consequences and I am willing to lay down my life for my people. Oh man, he would have been a great fellow. He would have been the great, he would have said things today that would have made every Nigerian uncomfortable. In that case, he would have said, I only wanted to broadcast to my people, to preach to them. Before I knew it, I was charged with treason. And those original charges were false because Justice Nyako set them aside and dismissed them in February 2017. And I was kept in prison for what was indeed trumped up charges. My Lord, I'm a human being. When the government came against me with such high-handedness, I was left with no option than to take up the measures I've taken up. He would have said he's a good person, he loves peace, but he was forced into war. Then he would become that leader that he wanted to be, because he would have said something that would sear the conscience of every Nigerian today. He would have made a case for the Igbo people. He didn't. Unfortunately, he didn't. It was an anticlimax.
Do you think he actually planned that this would have ended this way, or do you foresee from the things you know, because at some point you were called to represent him at some point as a legal counsel, do you think the man you met, the Nnamdi Kanu you knew, that you once went to court to represent, do you think the things you said now and the altercation he had with the judge in court, that is something that he may be regretting now, that he missed the opportunity, if I may borrow your words, to deliver that speech of a Mandela moment?
Yes, I believe that, Nnamdi has gone through a series of evolution. There are many ways to explain the Nnamdi phenomenon. First and foremost, I always ask myself, what makes a leader? Does the leader make the people, or do the people make the leader? I think there are there is what we call identity fusion affecting the Igbos as a result of the civil war. And that is why when you mention the word Biafra, it has this incredible impact on the people.
Yeah.
Yes. So, and they immediately transformed Nnamdi. Partly also because of the high-handedness of Nigerian government. When they arrested him in 2015, nobody knew him really, but they arrested him and made him the face of Biafra. They directed to his person their sentiments against Biafra. So they personified Biafra in him, and people responded immediately. They began to call him incredible names: Messiah, Savior, Prophet, Ahamadike, and all those things. They would go into anybody's head. These things went into his head. He stumbled upon extraordinary power. A man who had more than 5 million people willing to swear in his name. That was extraordinary power. When I met him in 2017, I said, "Hey, man, you've done very well." He said, "How?" I said, "You have 5 million people behind you. That's extraordinary. But when you come out of here, you're going to face the real problem. That is, you're going to deal with the fact that you can't give them Biafra." I told him this. I said, they expect you're going to give them Biafra. So when you step out of here, you're going to have a problem, because it will be a moment of reality when they realize that you can't give them Biafra. If I were you, I would convert the political capital, I mean the number support I have, into a political capital. Okay? Get align with all the former political agencies, the politicians, representatives, with your 5 million people, all the governors in the Southeast to be feeding from your hand, and then that will give you influence to shape things. He actually agreed with me. He said so. He said, "I see why I want to have you around me." He said that. So I was surprised when he came out and then began to boycott elections. I was so shocked. It was the opposite of what I wanted him to do. I wanted him to use his position, go to all the political candidates and say, "Hey, we will support you if you will advocate for Biafra. So what do we want you to do?" Well, we want you to go and read this manifesto and say you are for Biafra. And when you get to the Senate, you're going to move a motion for Biafra, for referendum. That's what I thought. And all these candidates will come,
but
signing up,
but
promising, believing.
but what you mentioned now, it actually happened in Anambra election 2019. Actually, when, if you recall, that Osita Chidoka contested against Chudo Kadi or Chudi Ofodile, to who is going to win the candidate of the UPP, then formed by Chekwas Okorie. And in their manifesto, they had referendum in it, which was the backbone of, when Nnamdi Kanu came out, Osita Chidoka was the person that drove him out. All those was done in preparation to gain that political favor, as you saw, as you discussed before now. So why was that, that political movement, as you advised, why do you think that wasn't carried along? Because there was an already waiting party. If you recall, there is a video out there when Professor Chukwu Charles Soludo, the now governor of Anambra State, when he reviewed that same book here referenced, written by Chuk Ofodile, he said in there that, Soludo talked about that movement and use, rather than the Biafra as a nation, but becomes an intellectual concept to use to drive that, narrative for a better Anibo. So what, again, without sounding broken, what didn't happen that momentum wasn't carried, and that's why UPP, I think, UPGA, either UPGA or UPP, why is it that eventually that wasn't carried through, and Osita Chidoka had to eventually leave that party and go back to PDP?
There could be several reasons that led to it, including Nnamdi's limited knowledge. There is this tendency among his supporters to think he's a genius, which is not correct. His actions suggested otherwise. So he probably didn't consider the ramifications of the options. Maybe he didn't. Two, he probably misjudged the power and influence that he had. He didn't realize it would not last. It was not sustainable because it was in conflict with the established institutions of the state. It was only a matter of time before they would clash. And he would do more and more things to sustain that power and to sustain the hope he gave the people. That was why he set up the BSS, Biafran Security Service, Intelligence Service, gave the uniform, and then and a whole lot of things. So it's lack of foresight, lack of in-depth knowledge of political dynamics, misjudging the situation, and getting carried away by the power and money that came, because he had influence. The Biafran brand is a magic. Nigerians were mobilized all over the world. I mean, Igbos were mobilized all over the world. They were contributing money. Some were paying huge amount of money. So I think IPOB was raking in at least 50 million a week. Then 50 million naira a week. And then, no, more than that, because you then have the politicians who were giving them big money. There were politicians giving them 100 million. All the politicians were after. I am, okay, hold on. I think I'm going to put on something here because.
Okay. People, let's wait for my guest to, I think there is a distraction in his vicinity. But as he comes back, I would want to find out from what he said. My guest talked about the Mandela moment, right? He talked about the Mandela moment. Okay. Now, I'm not trying to hold your thoughts here, but while you were talking, I was still thinking. You talked about the Mandela moment, assuming in the moment of the allocators, right? Had he said something today, many people in the comment section are saying it wouldn't have changed anything. It appears that the judgment was already predetermined. would it have changed anything if he had addressed the way you said it, addressed Nigerians, addressed Ndibo, pricked the conscience of Nigerians that this is what drove him to what he's doing, because Ndibo, he felt, were not being treated aright? Do you think that would have changed anything?
Absolutely.
Okay.
Excuse me. You see, it's a very strategic move. It will not change. First and foremost, the judge gave him the least uh, sentence he would have given him. It wouldn't have changed the sentence. But you know what? It would have changed the record, because his statement will form part of the record. Anybody looking at this case in history will hear his explanation, his justification. It will mitigate the gravity of the case in the minds of the people. That is what will spur on the debate on pardon. That will dominate the pardon discussion. It was very fundamental, because what you saw today was a man who lost his composure, who was taken out of court while judgment was delivered, who was yelling and shouting, a man who wasn't really convinced, a man who was afraid of consequences. He wasn't the man that braced the confidence, the consequences. Mandela said in his case, this was my offense, and if I have to die for it, so be it. He cited great people, Mahatma Gandhi and others, and said he was a man of peace, but he had no choice. That's what he could have said. It will not change the judgment, but the judgment is not the end of it. Remember, having given him life imprisonment, he's going to spend many years in detention. So it's a question now of how soon will Nnamdi be released on pardon, and what will be the kind of discussions leading to pardon. If he had made that statement he would have made today, the division in Igbo land, at least it would have brought Igbos together, because Igbos are polarized over Nnamdi. Majority of the Igbos don't support him, but they're afraid. The intelligentsia, the sophisticated Igbos don't support him, because they had felt that he had no explanation for his existence. So you know what Nnamdi would have done today if I were his counsel, if I was advising him? First and foremost, I would say Igbos died. Many Igbos died, and there's no explanation for that. So I want you, in your allocators, apologize to all those that died. I want you to state that it was not your intention for them to die. So he could have done that. Can you imagine if he had come today and said, listen, I am aware that our people died. I am aware that in the course of my struggle, situations arose beyond my control and people lost their lives. I am aware that some people took advantage and pursued their own objectives without my authorization. I have never, I said this, I have never sanctioned the death of an Igbo person. Even my rhetorics, all those things I said were intended to inspire Igbos. But when it came to a moment of actually ordering the death of anybody, I would never do that, because I cannot shed the blood of a fellow Igbo. You know, he could have said this. What would have done is forget what the judge does. Focus on what the people think. He could have stolen the soul, heart and soul of the Igbo people, bringing them together, uniting them around the cause. What we are going to have is those who felt wounded because they lost the relatives will begin to reconsider. In 6 months' time, discussions will be what drove him, that no leader is perfect. But today, based on what happens, you are going to see that the support of Nnamdi will begin to decline, because people are now going to say things they did not say before. They're going to ask questions that did not ask before. They're going to critique the Biafran project, okay, and ask, was it worth it? What was truly there? So that is actually, I think it was a great moment lost, and it's not going to come back. For a man who liked to hold the stage and they gave you the microphone, and you were to address the court today, he would have made a statement. Indeed, if I were him, I would have been preparing. His lawyers would have prepared his allocators, even in writing, so he would not make a mistake. So his eloquence will be displayed in the allocators. His eloquence, his intelligence, his great vision, his explanation will come in allocators. But that wasn't what happened. What happened today was an absolute disaster.
But many people in the comment section are saying that he's been speaking, that if it's about, would they have made, what difference would they have made that he spoke about the same thing today, considering that these are the things he's been speaking in some of, if not most of his online speeches and broadcasts?
Today was his greatest audience. Today was his greatest opportunity. How many people will go to Radio Biafra to listen? I never listen to Radio Biafra. I don't consider it a place I should go to listen. How many diplomats watch Radio Biafra? But today, the world watched the court. The world watched the court.
Correct.
Okay, so it's not the same. He had special audience because you know what? His Radio Biafra was a forum he controlled. His Facebook page was a forum he controlled. Today was a forum controlled by the Nigerian state. He addressed Nigerians today. Oh, it would have been a great thing. It would have been a great thing for him. But it was squandered, a catastrophic miscalculation. Of all his errors, this was the second biggest error. The first errors were the ESN, all those pronouncements about killing the policemen. Today was his closing argument. He could have made a statement that would live in history forever. That he could have become a very great man today. So, but instead, we saw an angry man. We saw a man that didn't change. We saw a man with outbursts. We saw a man threatening. We saw a man who failed to appreciate who lacked what we call situational awareness. Because an intelligent person should appreciate where he is. He was in the court, and this court was holding your life in his hand. And the judgment will shape your life very fundamentally. So you know what you gotta do? Put in a statement that becomes part of that history. So when people read this, listen to this judgment, they will also hear you. That was it. Okay. He blew that opportunity, sadly.
Okay. So let me pick your brain on this part.
I have to indicate, sorry. My battery is low, sadly. I didn't know we're going to use this phone to do it. So my battery is low, but guess what? Yeah, my battery is low. If this continues, we may have to change phone or we will have to end it. It's going to just let you know we have about 5 minutes.
No, it's fine. It's fine. Either we can change phone or we can move back to your system, but in that case we won't see your visuals, but then we may have to make do with your
we will change phone. I have a better phone with 95% battery.
So you can now while you can now probably
no, let's continue because it's plugged. It's charging as we're speaking.
Okay.
Let's go.
So that's fine. So I don't know what what you make of this, because this particular case, this particular statement he made here had been advanced multiple times, yet even on this date the same was also made.
An order. This motion, my lord, was filed on the 12th day of November, praying this honorable court for the following reliefs. An order referring the substantial constitutional questions raised in this trial to the Court of Appeal pursuant to Section 2952 of the Constitution of the Federal Republic of Nigeria, and an order staying further proceedings pending the determination of those referred questions. The supporting affidavit was deposed to by my younger brother, Prince Emmanuel Kanu, together with all annexures. My lord, my written address filed in support of the motion, wherein I adopted and argued the 3 jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord.
Okay.
My contention is very simple. That ab initio, this court lacks jurisdiction to try me. That this very court is a material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, and which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my Lord, nullifies this entire proceedings completely and totally. Because count 7, my Lord, does not exist in the laws of this very country.
Okay. Is it the count 7 is what you addressed at the beginning, right?
No, I addressed count 1. By the way, all that he said, all that you just displayed now is around nonsense. Nonsense. And you have to understand, you have to understand that I wouldn't use such word, nonsense, if I could avoid it. Complete nonsense. It is a continuation of his catastrophic mistake of defending himself. The only benefit in defending himself was he wanted to have a last Radio Biafra broadcast, because that's what it is. It's nothing. First and foremost, you have 7 counts. Even if one of the counts is defective, you still have 6 counts to face. Now, I haven't looked at the ones I don't think he was even convicted of count 7. So in other words, the judge decided to ignore that count. So okay, now they gave you 7 count charges, and let's say one of the counts is defective. That's not a basis to stop the entire trial. You still have 6. You could be convicted of 6. So
count 7 is the list there, because that's the 5 years actually. It's on the life. Basically, a death sentence committed to life is count 1, 2, 4, and 6.
Good. Let me tell you something. There were things. There are many ways. First and foremost, inclusion of count 7 does not make his trial defective. It doesn't make the entire trial defective. Indeed, it doesn't make the trial defective because the judge may. Okay, now let me tell you something about judgments. When a judgment has not been rendered, you don't know which way it will go. So if you think that count 7 is defective, you don't know whether the judgment is going to strike it out in the judgment. That's actual. Maybe the judgment was going to be count 7 is hereby struck out because so. So you cannot preempt the judgment because you don't know. The fact that the judge goes on to judgment, do you know whether he will agree with you in your argument? All you can do is to present your argument and wait. When judgment comes, you go on appeal if you're not satisfied. This idea of stopping the judgment, stopping the rendering of any judgment, that is daft. It doesn't exist anywhere. Court of appeal doesn't have that power. Court of appeal. But I knew that Court of Appeal wasn't going to do that. Okay, Court of Appeal wasn't going to do that.
Okay, I think it's the phone.
Yeah, okay. Sorry, that is it. I'm trying to get it out. Okay, so we're back on. Can you hear me?
Yes, I can hear you loud and clear.
Good. So the whole thing, I'm sorry to say this, is ridiculous. It made no sense. It made no sense at all. Okay.
Okay.
It made absolutely no sense.
Now, in the court opted for life imprisonment instead of death penalty, as was advanced by the prosecutor. Even though even though the prosecutor sought death, how common is this in terrorism cases in Nigeria, and what do you make of the judge reasoning, considering that within the week, a Boko Haram, one of the leaders, was sentenced to 20 years imprisonment. So what is the justification of somebody who have killed multiple individuals, bombed churches, led attacks, being sentenced 20 years? Isn't that one of those things that, in your considered opinion, might drive ethnic narrative that people will now say, wait a minute, is this because he is from this particular section of Nigeria? Why is the other people getting 20 years imprisonment and he's getting life imprisonment?
First and foremost, which count gave him life? Was it not count one?
1, 2, 1, 2, 4, and 6.
Okay, which one was 20 years? Because one of the count was 20 years.
20 years discount 3. No option of
Okay.
fine.
Okay. 20 years count 3. Okay. So, well, what you have to see is there are so many details that influence judgments. And that's why in many jurisdictions, we have what we call sentencing guideline. Because without a sentencing guideline, it is up to each judge to exercise discretion on what sentence he passes. We really don't want that. It's not a good thing to have situation where sentences vary, and somebody gets 4 years, somebody gets 8 years on the same set of offense. That is not fair. It's a problem. It could fire on narratives supporting special treatment for some people. So apparently, this judge had discretion, death penalty, or because for the prosecution to ask for death penalty, that means that the law allows that penalty. So there are supposed to be guidelines to be followed. That's what is done in the United States. There are sentencing guidelines. That is why rarely will American judges sentence you the day they convicted you. They will adjourn after conviction. They will adjourn for a month or two to prepare for sentencing. That is when all these additional factors are considered, mitigating circumstances considered, pleas and intervention considered, victim impact statement considered. All this will be done in advanced society. Here in Nigeria, sentencing is done almost immediately. So without sentencing guideline and without mandatory sentencing options, because you see, the law also sometimes fixes mandatory penalty. So once you are found guilty, automatically you will be sentenced to given a particular sentence. Apparently, there's no mandatory sentence for death, which made it possible for the judge to exercise discretion and make it life. And apparently, he could have made it less. So I don't want to conclude that there was a targeting, that was ethnic inference here. First and foremost, it wasn't the same judge that tried the case, the other case in Sokoto, and I don't know the facts of that case. I don't know the gravity of it.
Now, one thing, taking a glance on this, one thing that is apparent here is that the convict pleaded guilty. Could that have then made it much simpler?
Absolutely.
It says
yes, absolutely.
The Federal High Court in Abuja has convicted Hussein Imam, a Boko Haram commander known as Maitangran, and sentenced him to 20 years in prison. Given the verdict on Tuesday, that's 2 days ago, Dr. Witte, the presiding judge, ruled that Ismail is guilty of all 4 counts filed against him by the federal government, although the cumulative sentence amounted to 75 years and 15 years to count 1 and 20, and the 20 year each on count 2. Now, but the bottom line here is, from the headline, you can see he pleaded guilty. So probably that is what may have changed that case. Don't you think so?
It is a factor, absolutely. And there are many things. For instance, the prosecution did not ask for death penalty because of the guilty plea. Two, the guilty plea made it easy for the courts to come to a conclusion and resolve this. The case didn't have to drag out. His demeanor also indicates whether he is likely to continue the offense or whether he is truly a repentant fellow, remorseful. Nnamdi didn't have that such demeanor. Two, his role in the chain of command. Is he the head of the group or is he a junior officer? These things are factored in, and there are several things. But one thing we must avoid is the sentiment of the people on social media. People don't understand a whole lot of things. They allow things. I'll give you an example. Yesterday, I was reading about a story of a soldier who was fired, who was removed from the army because he shot back at the Boko Haram. So people are sensationalizing this because it suggested, oh, this soldier shouldn't have shot at Boko Haram. He was being punished for fighting. Those things are very ridiculous because he doesn't follow the dictates. You come in the military operational thing, your commander may ask you to hold fire. Don't shoot until we're in the best position to shoot. So no soldier goes to the distance and randomly shoots without command. If that officer shot at Boko Haram, he shot without being commanded to shoot. That is a egregious violation of battlefield rules. So I can understand why he would be disciplined. He was even lucky they didn't shoot him. Because sometimes they ask you, hey, hold your fire. Don't hide, conceal your presence. Let the enemy not know we're here, so that we're well positioned to confront them. Because if you allow the enemies too early by firing your shot, they could escape or they could prepare to attack us. So if you are a soldier and you shoot without being commanded to shoot, you are lucky. Your commander could shoot you because you're exposing you are the troop. You're exposing your colleagues. So the point I'm trying to make is, let us not be carried away by the sentiments on social media. I have never seen what I am seeing now, where people who know nothing about the law, they are giving the opinion, they are chorusing that, oh, no written law, the law was repealed everywhere. On my posts on social media, people will still come and say, and what law will he be charged with? What written law? That's nonsense. That's why when you ask me to respond to his statements in the court, I respond unequivocally. That's absolute nonsense. So that is what is being peddled. I wouldn't know why the judge gave 20 years instead of life. It is a different case, different judge, different fact pattern, and possibly different sections of the law, which is what we don't know. But the conduct of the defendant is important. A remorseful, the remorseful defendant who pleaded guilty and is and cooperates with the government. Because let me tell you something: when that guy pleaded guilty, he must have cooperated with investigation. He must have given testimony that will help catch other people involved in his group. He might have provided valuable intelligence. In fact, it's even possible to give him immunity from prosecution. This is done all the time. You catch one out of several terrorists. He cooperates with the government, gives useful information that helps the arrest of others. He could be given immunities. He could be given money. He could be sent overseas and asked to live comfortably. So let people not overreact. You need to have the facts before you draw conclusions.
Now, the judge ordered that Kanu be denied access to digital devices and that his broadcasting equipment be forfeited. Is that a legally sound and enforceable ruling? I mean, because also, what could be the challenges here? Recall that the judge said that he mentioned specifically that he will not advise that he be kept in Kuje. So where do you think he can be taken? And he said he should be in a and at someone who was also in Kuje and understand how Kuje, because I recall many years ago you sacked the former EFCC chairwoman, when some of the things you wrote out of Kuje was very, very uncomfortable, that at some point those things led to her sack. So what is that thing with Kuje that the judge is afraid of Kanu being sent to Kuje?
You know what? You know why I'm laughing? Because I predicted he would not be sent to Kuje. I had initially said he was going to Kuje, but I came back and said no, he will not go to Kuje because in Kuje, Kuje is a prison. And prison has its own regulation. Inmates are entitled to certain things. They're entitled to communicate. They have visitors, and it's a large population, a large community, so they mingle and they can operate by proxies. If you put a man like Nnamdi in Kuje, there could be problems, and the problems will be he will mingle with other inmates. If you say he's a terrorist, he could recruit more people from there, and with easy access to digital devices, he could uh, address his members. He could run IPOB from Kuje prison. Kuje prison is a medium facility prison, and inmates there are given privileges. I was once in Kuje. I knew how it works. Influential inmates will have even air conditioner in their cell. They will have phone. It's not officially allowed, but there are many ways to get phone in Kuje. More than half the inmates in Kuje have telephone. Okay, so now it will be problematic to do so. What I don't know, which needs to be thoroughly examined, is when a judge sentences you to prison, the details of your life in prison supposed to be left for the prison service, that is correctional service. It is unusual for the judge to begin to dictate the details of treatment you will have, like saying he shouldn't have digital devices. You should leave it for the facility that the custodial facility where he is, because the custodial facility will have rules. Okay, if prisoners are allowed to do certain things, then Nnamdi should be allowed to do certain things. That is what the same thing. So that is what I find. So I understand why he should not be allowed to have a phone. I understand their concerns. He could do things. He could do things. Powerful inmates could even order the execution of somebody, or interfere or revenge against witnesses from prison. They can do that. So what happens if that is the case? It is for the prison authority to devise a method to monitor that inmate and prevent these things. It's not for the judge to set the standard of treatment he should enjoy in prison. Okay, so if he goes on appeal on that, the Court of Appeal may remove that, but the Court of Appeal will not quash the sentence itself. They can look into those details.
Now,
and by the way, point of correction, I and Farida Waziri, when she used the EFCC to harass me and detain me, and I wrote a lot from detention.
Yes.
I was actually detained in EFCC facility. I was writing from EFCC facility.
Oh, that was not Kuje.
No, it wasn't Kuje. It was much later, but that I was remanded in Kuje for a separate thing. Yes.
Yeah, but I read a lot through elumba.com then.
Yes. It will in my book. It will be in my book because I did I wrote my memoir yet to be published. But I detailed everything that happened between me and EFCC.
Okay. Now, Kanu is to be kept in protective custody. What does that typically mean in Nigerian's correctional system? And if I may add, how might that affect his right, security, and ability to communicate, considering what you said before?
Well, he was never in protective custody, by the way. You see, this is what irony of life.
Yeah, but that's what
they said.
Now demanding.
Yeah, of course. Now the judge can do so. Previously, it was not done. And protective custody is actually, it's a very glorified way to talk of solitary confinement or isolation. Oh yes, because you see, they will say it is in the interest of the inmates. That's why they call it protective. Okay, in other words, it is in his interest to isolate him. Okay, so you call it protective custody, but it is actually an isolation. Okay, so the judge can say that it is not more or less an order. It is a statement that guides the prison authority. It's not something that forces prison authority to do anything. It is a guidance. He will be in protective, they will call it protective custody. But this is what's going to happen. When Nnamdi was there the first time, they put him in a single room cell where he was alone by himself. He initially started with some people. Eventually, he became very influential and powerful and had money to impress everybody. So they kept him in a room to himself. That protects him. That is his cell where he was the only one there. So it meant that no inmate cannot stab him in the night. Do you understand it? Things cannot happen. Because when you lock people up in the same cell and in the night they'll go to sleep, okay, what if one of them stabs the other, okay, and kills the other, poisons the other? So in a way, giving you an isolated room, a room by yourself, can be considered protective, but it also makes it easy for you to be monitored and observed. Because if people go into that room, nobody will be allowed to go into that room without the notice of the warders. On the other hand, if you're in a cell with 10 people, then you have 10 people to conspire with, or 10 people you can recruit someone from to run errands for you, to hide things for you. Okay, and then when they come to search a cell occupied by 10 inmates, it's more difficult to search the cell, and the need to search them might have been triggered by the conduct of one of them. So the other 9 are innocent. Why are you subjecting all of them to this search? But if it is one inmate in one room, when they come, they'll search everything. They can come anytime. They can come midnight. But certainly, if Nnamdi is in Kuje, he will have funds. He will do a lot of things to have funds. He will bribe warders to give him funds as well. Those things will happen. Now, the question I thought you will ask is, what sort of special custodial arrangement can be made for him? I already said that in my post 3 days ago, 4 days ago. I said they will probably put him in an isolated house, just the way they did Zaki. The only difference.
Zaki.
Yes, Zaki. Sorry. So the only difference is that the place he is to be detained will be under the control of the correctional services, no longer under the control of DSS. Yes, once sentenced by court, you have no business with the police or EFCC or DSS. However, being the agency in charge of this matter, the DSS will continue to have access and influence on his custodial arrangement. So they can come to interview him any moment. They can always say they're pursuing other ESN members and they want to interview Kanu. So they will always be allowed to interview him. They can always also come in and say, hey, he's got a phone, whatever, that they're searching. But DSS cannot operate without the approval of the correctional services and support of correctional services. So I would expect that if they're searching him for anything, the DSS, if DSS are coming to do anything with Kanu, prison officers will be present, because he is in their custody now. That he is the responsibility of the prison authority, no longer EFCC. I mean, no longer DSS. DSS must get permission of the prison to access where he is. So I don't know what custodial arrangement, but another thing that could happen is, when the court said he should not be in Kuje, that is tricky, because if the concern is isolation, if you want him to be isolated, if you want him to be protected, protective custody and isolation custody can be done in Kuje. They have facility for that. They have isolation place. They have solitary confinement. They have, they have other things. Okay. But it will be hard for Nnamdi Kanu if you deny him that access. Okay. It will be, because the only way he will continue to be relevant or reach the outside world is when his visitors come and his legal consultants. Something new. Nigerian courts have created an arrangement where a lawyer is defending you, but in Mufti as a legal consultant. He's a lawyer. The lawyers wrote all those briefs. All those things is written by his lawyers. So, in other words, he was receiving legal representation, except to the point of talking. He just wanted to talk, and that is very sad. Very sad. He wanted to talk, and he spoiled everything talking.
Anyway, on this issue of self-determination versus terrorism, there is tension between Kanu's claim to self-determination, that is the Biafran struggle, and the court's framing of his actions within this Biafran struggle as terrorism. Then, from a constitutional perspective, how does Nigerian law reconcile or fail to reconcile political dissent with criminal terrorism charges?
Well, let me make this clear to you. Hold on. Let me see if I can pull up something I wrote on this subject. Okay, when you talk of you don't have rights to secede. Okay, that's not self-determination. There are conflicts in international law. You have what we call territorial integrity. Territorial integrity of states. Okay, territorial integrity of states. One quick second, please. I'm not going to waste your time, but I cited the applicable law in the United States and law in Canada, where it was stated clearly that you don't have rights. What's the original meaning of fucking? You don't have rights to. Nobody has that right to secede. Secession is not a right that anyone can claim. I'm just gonna get it because I saw it. I just saw it. I saw that I posted it with the map of Biafra to argue that point. You don't have that. It came up in the United States, something in Texas, the rule that no such right exists. And then it also came up in Canada, no such right exists. Okay. So, however.
What do you mean? Which right? Right of self-determination?
Well, self-determination in the context of a country like Nigeria is to be done within the constitutional process, demanding better life, better governance. It doesn't encourage you to operate outside the law. There are certain exceptions in international law, very rare, okay, where those options don't exist. So it is totally arguable whether anybody can say that Nigeria does not have any mechanism for addressing these social crises that Nnamdi has identified. All these social crises he identified, could they be addressed without the necessity of secession and violence? Because one thing you have to understand when you come to secession is that your right to self-determination, when you say you have such right, you must also understand the concept of territorial integrity in international law, that almost every country in this world will take steps to preserve its territorial integrity, to make sure that you don't, I think I have found it here. Okay. So, okay. All right. Okay, response. Historical responses to secession movement. Okay, it was in Canada, Quebec deals with it, United States deals with it, and it led to a civil war. Civil war in the US was actually secession attempt, if you understand that. It led to civil war in the distance. So it's very important to understand that these rights are not absolute. They're not absolute at all. We have to be very, very conscious of these things. These rights are not absolute. They will be, okay, hold on. And yes, this is another one I was looking for. Legality of secession. How lawful is secession? Okay, well, we have a national law position. As a United States, the Supreme Court ruled in Texas versus White, 1869, that states cannot unilaterally secede from the Union. We've been talking of states. Nnamdi is not a state. Nnamdi is an individual. But it could still have been tolerable
Yeah, but he's representing an organization.
Well, an organization is not state.
Sure.
Okay, on his organization is not state. Indeed, his organization is a registered company in the United Kingdom. So it's not a state. Okay, because if it is a state, there could have been at least some level of legitimacy under it. Okay, so you have a constitutional provision varies. I said some national constitutions may implicitly reject or ignore the right to secede by emphasizing national unity and integrity. A constitution fails to provide a mechanism for secession generally. Okay, a constitution that fails to provide mechanism for secession generally implies that attempts to do so will be deemed illegal. Nigerian constitution says it is indivisible. Okay, of course we can challenge it politically. We can make that argument. Oh no, you can't do this. It's wrong. It's this. But when you take any step to secede, you can be deemed to be committing treason. And there is international law situation. Territorial integrity is a concept in international law. Now, self-determination, because when you come to international law, you have conflicting theories. Territorial integrity says that a country has right to retain its border and make sure it is not changed, either by fractionating that country. Then you have the concept of self-determination, and this is what I wrote in my post. I said, this principle grants people the right to determine their political status and pursue their economic, social, and cultural development. However, self-determination is often applied within the context of the colonization or situations involving significant oppression rather than a blanket justification for secession. Do you understand it? It is not a blanket justification for secession. You can't just secede and cite this. In 1967, Ojukwu, remember Ojukwu was head of a region. So, but in 1967, Ojukwu was justified. The pogrom, 66, 67, the pogrom, the persecution of the Igbos in other parts of Nigeria, and the failure of the federal government and the regional government in the north to stop these persecutions justify that extreme circumstance where secession would be justified. And it was a secession initiated by a state, by a regional government, the eastern region. It wasn't a secession initiated by Adakaboro. Yes, like the one Adakaboro tried, if you remember Nigerian history. Okay.
Sure.
And interestingly, when Adakaboro tried it, it was Ojukwu that suppressed him. The events of 1966 in Nigeria qualify for situations involving significant oppression. Hence, secession was justified in 1967, but not justified now.
Well, I think it's a matter of semantics, because many, especially those Ndibo who may be emotionally charged as to the things happening in Nigeria, may say, well, we are being oppressed, and therefore, that's their thinking, that if they feel that they are oppressed, and why can't they demand that they have their own country? But let me come to the next question quickly, which is the international law, or rather international law, and its implication to this judgment that was given today. Does this case raise any potential question under international law? For example, human rights norms, dual citizenship issues. Recall that Nnamdi Kanu holds a British nationality, or the right to political expression, but because many will tell you that, well, the reason why this is happening is because he's expressing himself politically, but in a different dimension. Or, as I had mentioned earlier in an earlier broadcast that I had, what could be the implication of those who are IPOB members who are in the diaspora by this judgment?
Okay, you said so many things. By the way, let me just say one more thing about the last question. You said it's semantic, that he will say self-determination, will say, okay, it could be semantic, but remember, if Nigerian government could suppress Biafra in 1967, the same government can suppress Nnamdi today. So it is a question of firepower. It's a question of pragmatism. Okay, it's not sentimental. Okay, right. It's then secondly, now coming to this other question internationally, of course, every case in Nigeria, even the case of Sanda, the woman that killed her husband. They have ramifications when you evaluate legal development in Nigeria, the independence of the judiciary, the quality of judgment, and then, of course, the issue of right of agitation. Nnamdi is a historical figure. He will be featured in all the discussions. I'm very sure that in legal literatures dealing with self-determination, terrorism, and all these things, Nnamdi Kanu's case will feature. No doubt about it. Now, how it features or conclusions people draw from it will depend. It will vary from situation to situation. For instance, in the context of Nigeria's standing on international law, this case will come up. I mean, on human rights. Okay, this case will come up. There arises agitation in the southeast. A group of people felt marginalized. It's important, but they will not come to the point of saying, "Oh yes, Nnamdi did the right thing. Nnamdi did the right thing." No. Okay, the violence in the southeast, the sit at home was senseless. It was not rational. It served no purpose except the ego of one man. Nnamdi wanted to show how strong he is, his appeal, his power, that he could issue an order and people will obey it. So he did it. But he didn't just allow them to obey it willingly. He enforced it. Sit at home was enforced by the barrel of the gun. People were shot and killed. So assuming he had ordered it and encouraged the people to sit at home, and everybody sat at home voluntarily, you can't blame him for saying that. Yes, if you tell Nigerians, listen, to sympathize with my cause, fellow Igbos, to sympathize with what happened to Biafra, all of you should sit at home on Monday, boycott war. Calling for a boycott is not a crime. It is when you start attacking people when you start forcing people to boycott, that is when it becomes a problem. So nobody in this world will sanction Nnamdi's method. His vitriol, his attacks, this did not help the Igbos. It further alienated the Igbos. Okay, and then his lack of inclusion. His movement did not include the political class, the political elites among the Igbos, the governors, the senators. They were not part of it. They only came out after his incarceration. They are pleading for him to be released. So how can you form Biafra and exclude those people? They are the most influential people in Biafra. So essentially, everybody understood that Nnamdi was embarking on a gambit that will not achieve anything. Nnamdi knew that as well. So that's why we begin to question, what is his motive? Was his motive to get Biafra or to reach himself? Because certainly, the way he was going will not get Biafra. It will make it even more impossible.
So, what's like I said before? What's the
those in diaspora? One quick second. Those in diaspora. Now, if you look at
his dual citizenship.
Yes. No, dual citizenship will not make any difference because he's a Nigerian citizen. You see? Okay. Whatever claim, Britain has no claim against Nigeria or citizenship because he was a Nigerian citizen, born in Nigeria. He naturalized in the United Kingdom. United Kingdom can revoke his citizenship, but Nigeria can't. Do you understand? So,
does he, if you talk about revocation, does it then stand that danger of his citizens being revoked because of
yes.
terrorism charges?
Britain could do so if they find sufficient reasons. If they can do their own investigation, find the justification or merit in the Nigerian proceedings. One problem with Nigerian proceeding was the long time, the delay was terrible. The delay was too long, and when you delay a person too long, so you actually forfeit your right to try the person. If you recalled, I previously wrote that Nigerian government should release Nnamdi Kanu. I wrote it. I wrote it about 3 weeks ago, a month ago. I was saying he should be released. And I made it clear that the reason they should release him was because they couldn't try him. I said, if you can't try that guy, release him. Absolutely. So, but they can try him. The trial went ahead. Once we got to the point of him making his defense, I stopped saying they should release him. He should make his defense, explain his position. So now about the diaspora, I am quite disappointed by some of Igbos in the diaspora. They refuse to understand what is at stake, and they get carried away by that Biafran sentiment, and they're contributing money to Nnamdi Kanu and his IPOB. That was wrong. However, now that Nnamdi has been convicted, if effort is made towards getting pardon, getting amnesty for the combatants in the Southeast, reaching reconciliation, empowering those kids, holding them accountable, seizing their guns. If that is the contribution, I think it is good. But supporting Nnamdi and what he was preaching that time was daft. And if Nigerian government was serious, they should target the financing of IPOB. And being a proscribed group, if you send money to them, they should arrest you in Nigeria. All these are people. I mean, I know they'll be angry I say these things, but honestly, if you are supporting an organization that has been proscribed and an organization responsible for the massacre, killing of people and the violence, then you have no excuse. Absolutely. It's very important to see.
If we take America, for instance, a place that you understand the legal framework very well, do those IPOB members in America, should they have any cause to worry after today's judgment?
Well, yes, of course they have something to worry. They should. It's now clear to them that their Biafra is not coming. That Nnamdi's Biafra is not coming. Well, yes, they can actually be arrested if they can be identified. Honestly, if you are identified to be supporting IPOB after his prescription, you can be arrested. They have enough basis to arrest you if they see you in Nigeria. But the whole rendition
in America,
not in America. Not in America. Not in America. So, but of course, if you are inciting violence, America can arrest you. So also, however, if America were to declare IPOB a terrorist organization, then they will be arrested for anything they do further with IPOB. But in America, IPOB is not proscribed in America, it's not declared a terrorist organization in America. So associating with IPOB does not violate an American law.
Do you agree that one of the reasons why this judgment was given at all costs is to, to set a legal precedent for how Nigeria deals with other separatist movement going forward?
Well, it will certainly set a precedent, but there have been many precedents set before. Remember the resource control war by the river militants. Even though they were not asking for their own state, they were challenging the Nigerian state in a fundamental sense.
But none was jailed. None was jailed. Aside Okar that was jailed in
Yes. But there were. That's what I'm trying to say. When it comes to precedent, that was a precedent. It was a form of resolution. They resolved it without jailing people. That set a precedent. So now, in terms of judicial precedent, this is a major one. Okay. It's a major one. It is important, but its impact is more in relation to Biafrans who has reached them and their future people. Okay, it is a major impact on how these things. Of course, the same law would be applied if someone else in any other part of Nigeria tries it, but I don't really see. Okay, yes, certainly. Obohu or Iboho. Sunday, yes, he was the person that this president could have applied to, okay, because he did something very close to what Nnamdi did. So, however, Iboho was resolved politically instead of judicially. I'm sure people are complaining, but also look at people will say, why couldn't it be different? Iboho was stopped. Can you hear me?
Yes, I can hear you.
Yes, Iboho was stopped when he made his move. Or rather, Iboho stopped. It was terrible, but Iboho was captured, and it was possible. But that of Nnamdi spread, and then you have all these. Anonymous actor, or not anonymous, but they were acting on his name, and he stayed in UK and continued to run show for a very prolonged period of time. That's if you look from 2015, you see that so much happened. It is a case of unique essence. I don't see it because when you talk of precedent, you must have similar facts in order to deal with precedents. Otherwise, the effect of the precedent is limited if the facts are different. So Nnamdi was unique, very unique, very, very unique in many ways.
Okay, so before we round up, Barrister Emeka here, now what next? Actually, what right does he? Okay, I rephrase it this way: what next? Where do we go from here? He's going to
Okay,
be.
this is
He's going to appeal court. Hopefully by
well,
next
he's
week.
going to appeal. Yes, he's going to go to appeal court, but that's if I were him, that's not where the hope lies. The appeal court will uphold the judgment. There, I don't see basis to I don't see strong appellable grounds for appeal. I mean, okay. Now let me tell you something. You go to appeal, and let's say they strike out 2 of the counts and find you guilty of 1 life imprisonment. You have only 1 life anyway. So I'm not saying he shouldn't pursue the appeal. He should pursue the appeal, but that's not where the solution is going to come from. And indeed, the appeal may delay his pardon. Because when you try to do pardon, they will say, let us wait and exhaust the appeal. Absolutely. Because
So
when you're appealing a case, you may not be in that state to ask for pardon. Because when you ask for pardon, they'll give you their terms. And that's actually the importance of getting him convicted before pardoning him. They want to pardon him. The pressure for his release is there. So I think he's going to come out after in a Tinubu's 2nd term.
What? That long?
Yes. Why would he come out? Why would he come out now? There's no strategic benefit. If he made the statement, if he made the speech, I thought he could have made, that would have fastened his distance. But he didn't make the speech. So there is no, what is the relevance? Many Igbos are divided over him. Not every Igbo is supporting. People are now questioning him. So, the governors don't support him. Soludo doesn't support him. Bad doesn't support him. The guy in Akwebom doesn't support him. I mean, Ibo doesn't support him. The guy in Imo State definitely doesn't support him. And then Abia guy should be careful. He won't support him either. Nobody. Even Obi doesn't support him. Okay. So,
So your prediction is that he's going to be there until Tinubu wins 2nd term.
Yes. Yes.
But don't you think, some have looked at it, myself included, that probably is going to be the chess card for this, because Tinubu doesn't have much inroad into the Southeast, he can use it as his bargaining chip and get some inroads regarding 2027.
No, Tinubu now has inroad in the Southeast, especially if there is no chance that Obi is going to win. If Obi is not in the picture, what happened in the Anambra State elections will happen in the presidential election, which is Obi will lose. So,
Obi is in the picture.
Okay, well, he has to be realistically in the picture with a chance of victory. Okay, because his persuasive ability seems to have been diminished as seen in the Anambra State recent election. Now, let me tell you how strong Tinubu wasn't strong in the Southeast, but he is now strong. Mba has gone to APC with his infrastructure and political support. Imo State guy is in control. Okay, and politics, when they lose the election, all the oppositions will come under you. 2, Soludo had already pledged to join APC very soon. The guy in Ebonyi is APC guy. And what do you think Oti is going to do? Oti is going to join APC soon, especially PDP continues in this disastrous performance. So So, and when all these governors are APC governors, they would support Tinubu. Absolutely.
Well,
These are
these
and
are political permutations.
by the way, do you think the Northerners will support pardon for Nnamdi Kanu?
No, sure, they wouldn't.
Okay, if they wouldn't, then why would Tinubu annoy the Northerners, lose the Northerners in order to win the Easterners? That means that he will lose more than he will gain. So I think what Tinubu is going to release him as a legacy project, not as a campaign strategy. A campaign strategy, if he will influence the elections in favor of Tinubu, Tinubu will forgive him. What I mean in favor of Tinubu, that's more than what Tinubu will gain from the Northern support.
So
because
I understand the point you're making.
Let me give you an example. If releasing a Nnamdi will give Tinubu extra 1 million votes from the east, but will cause him to lose 2 million votes from the north, he will not release Nnamdi. There's no benefit there. So what he wants to do, what I think he's going to do is keep him there. And because if you release him, he could be a problem for the governors. Absolutely. He still has massive support of Biafra, the IPOB people. So you don't want him to do that. Okay? He could become a problem for them. So what they're going to do is, after the his second term, then maybe in the middle of his second term, as a legacy project, as a man of peace, bringing Nigeria together, will release him on pardon. But there's another thing that could be done. Let me tell you something else I will expect, which could result in him being released sooner. If the government commits to a reconciliation program, that is, let us assuage the feelings of the Southeast. What is it that left them feeling so alienated that they had to do these things? Let us support. Let's reconcile. And then call a conference, a settlement negotiation conference, mediation conference. Nnamdi's release will be a factor. And whoever is involved in that reconciliation effort will be asking for his release, because if you keep him in prison, how can you say you are reconciling? So that is what could bring him out sooner. But if there is no commitment to that reconciliation, and by the way, it is such a reconciliation program that can make the Northerners calm down. Also, there will be similar negotiation in the North. You see an attempt to talk and mediate with the bandits and Boko Haram people. If that sort of talk continues, there will be need to also start a similar talk with IPOB. So invariably, Kanu may come out very soon, okay, in the context of reconciliation, because you cannot keep Kanu in prison and you're negotiating with terrorists from the north. Okay. Yeah, sure. That's going to be, it's going to be used as a way of buying the support of the Igbos in dealing with terrorists. If you're negotiating with terrorists, the Igbos will have to shut up if you can tell them that you will also bring Nnamdi out. So it's a very strategic calculation. Yeah.
So what you're saying in essence now is, if by next week the public does not see that the legal team goes to appeal, that means that the political negotiation is in high gear. Is that
well, they have a long time to go and appeal. They have 90 days to go and appeal. I won't judge it next week. If I were them, I will not rush on appeal. I will sit down and appraise what happened and strategize and even speak to people. Okay. And then if they go on appeal, if the government wants to release you, if there are impetus to release you, strong impetus to release you, yes, they can do so. They will avoid that argument. It's when they don't want to release you that they will say you're on appeal. But if they want to release you, dismissing the appeal becomes part of the settlement. If pardoned, Nnamdi should seek for pardon. But again, he lost a great opportunity today. He can still talk to his political representatives, the senators that talk to him, and if he has good people who will continue to mobilize Igbo youth, then they can be demanding for his release. The unfortunate thing is the violence, killing themselves. That's what alienates the Igbos.
So do you then foresee, now that it has come to this, do you foresee where the violence in the southeast comes down, or that the temperature kind of goes up because of
It,
this verdict today?
it has to come down. There's
Okay.
no option. There's no option. It has to come down. It's like when you go to war and your king is captured, you surrender. Okay. so what we got? Any violence in the southeast that continues is all related to Nnamdi Kanu. They took down Epa. They took down Nnamdi Kanu. It is a strong demonstration that these people are not above the law. It's a demonstration of accountability. So whatever you do, you too could go down. It is also an inspiration for those fighting IPOB security forces, whoever they are. It's a way of saying to them, hey, you're doing a good job, keep going. So I think
Mm.
IPOB is essentially finished.
Mm. Anyway, that's a very fine place to anchor with. Barrister
Thank you.
Mekugoni, once more, thank you very much for your time.
You're welcome. You're
It's
welcome.
been a pleasure to have you here. Thank you.
You're welcome. Bye-bye. Thank you.
Bye-bye. So that has been my one-on-one conversation with Barrister Emeka Ugonye. Yeah, I mean, you've heard all the conversation. You have all his take. I would beg you to join me tomorrow, 7 o'clock Nigerian time, 6 o'clock UK time, 1 o'clock Washington, D.C. I will be having another roundtable discussion on this platform anchored by myself. And this discussion is going to be on the unreported, unspoken genocide happening in Gaza, Borno State. I had spoken to individuals who are from there and the victims, their leaders. What my ears have heard in the last couple of days, I'm bringing them all tomorrow in here. They will speak. Just make sure you do not cry. It's unbelievable. And I promised, as long as many of them are willing to speak, we will keep bringing them here every Friday, 7 p.m., to have this conversation, the State of the Nation Roundtable conversation on Yenje Media. On that note, I say thank you once more for being part of this program this evening. My name is still Mazi Ezoke. Please like, share, and subscribe to this platform. Good night from my side. Bye for now.
La la la.